Hello again. We continue now with Chapter 4, only this time moving on to Parts B and C. And in the 5th edition book, those two parts begin on page 68. This is for the classification of law subject matter, the chapter of the chapter name of Chapter 4, and it's all relative to the Introduction to Paralegal Studies, a Critical Thinking Approach, 5th edition by Currier and Eimerman. My usual warning. This chapter, as you already know, covered federal versus state. We covered that in the Part A presentation lecture, and it also covers the criminal and civil law section and substantive law versus procedural law. This particular presentation is going to focus on these two topics: criminal versus civil law and substantive law versus procedural law. Looking back again at the classification of the law, so you don't forget the whole picture, so to say, in this chapter, is to understand that law is classified in the United States into state and federal law, each of which include both civil and criminal law, and both civil and criminal law have substantive and procedural law involved in them. And these are some examples of substantive civil law. This is an example of procedural law in civil matters, and there are many others. Substantive, two of many others in the criminal context, and procedural in the context of criminal as well. And we begin with a comparison chart. There are two slides to this. This first slide is describing a few of the areas of civil and criminal law and comparing the two, civil being in this first column, second column, third column being criminal. And here we look first to the type of harm. In other words, when there is a harm to a person, it would be a civil crime or a civil wrong, a private injury between or among people and business. If it's a criminal harm, it's a harm to society as a whole. The names of the parties in a civil claim are plaintiff and defendant. In a criminal claim, the state is the plaintiff, and we still use the terminology defendant in most states and in the federal system for the criminal types of claims. The prosecutor in a private claim, a civil claim, would be an individual or sometimes a business. The government might be involved in some types of civil claims. If there are civil penalties, for example, in a administrative type of action, that would be that might have some civil elements to it. The prosecutor of the claim is the person that was harmed. The government, of course, is the criminal, is the plaintiff and the defendant's. The prosecutor in is the government in a criminal type of claim. Next, in looking at the civil and criminal law comparison chart, the next slide shows us a couple of, well, let's begin with the standard of proof. Standard of proof is explained in the textbook on page 60-something. Let me look. Page 69 begins a conversation in the book about the standard of proof. And as you'll see there, the standard of proof is the idea that the jury must be convinced that the harm was done. And in a civil claim, there is a lower standard of proof than there is in a criminal claim. As you'll see in the book on page 69, there is a definition of preponderance of the evidence. And this is the standard of proof that, as pointed out already, is most commonly used in civil trials. And so the evidence presented by the plaintiff must prove that it is more likely than not that the defendant committed the wrong. If you think of the scales of justice as a measuring tool of sorts, a visual illustration, I should say, of preponderance of the evidence, you would see that the side that has the most evidence to prove the claim is possibly meeting their burden of proof of preponderance of the evidence. In a criminal claim, because the sanctions and remedies, we're going to discuss down here in a minute, because the sanctions and remedies are greater in a criminal claim than in a civil claim, the standard of proof is heightened to that called beyond a reasonable doubt. In the earlier days, even in the earlier days when I was learning law, 30 years ago, we called it beyond a shadow of a doubt. And now they call it beyond a reasonable doubt. Beyond a reasonable doubt, again, page 69 of the textbook, is defined as the standard of proof used in criminal trials, and that the evidence presented must be so conclusive and complete that all reasonable doubts regarding the facts are removed from the jurors' minds. So again, it's a higher degree than preponderance of the evidence because of the sanctions available, and that we'll go into in just a minute. Now, the outcome of a civil claim, that's where we look at judgment. In a civil claim, the outcome of the claim against the defendant is that the defendant is either liable or not liable to the plaintiff. In a criminal claim, it's guilty or not guilty for the crime. In the sanctions and remedies section that I briefly introduced to you a minute ago, we have in the civil claims damages or injunctions, and damages are compensatory damages or nominal damages, and there are also punitive damages available in civil claims, and we'll talk more about that in a little bit. But the important thing to understand right now is that there are differences in the types of sanctions or remedies available in a civil claim. And a remedy just meaning, what can the court do to put the plaintiff in a civil claim back to the position the plaintiff was in prior to the defendant or defendants having caused harm. The sanctions or remedies in criminal claims is imprisonment, fines, or the death penalty, depending on if it's a death penalty state. And so that would be applicable in a criminal claim. Civil claims don't have, people are not imprisoned for negligence toward another person. This is criminal only. The source of law. Relating this chapter back to chapter 3, we begin our journey into any type of claim or case that we're working on with what kind of law governs, and we need to know what source to look to in determining what type of harm was done. And harms are harms, for example, in a civil claim such as an auto accident. Those are defined in either common law or statutes. In other words, the rules of law, or the authority that we turn to seek an answer to the plaintiff's problem, and to see if there's any liability or not, or perhaps any damages available to the plaintiff, are found in common law and in statutes. However, in criminal, you'll see that that criminal claims come from statutes. It's very rare, very, very rare, for there to be a common law claim for a criminal type of offense. statutes define criminal types of offenses, and if you want to jump ahead in your book to Chapter 10, the first couple of pages of Chapter 10 in the textbook, which we don't cover in this class, we don't cover Chapter 10, will explain that if there is no law, there is no crime. And this is founded on our inherent rights, our constitutional rights, that is, to due process. And in order for there to be a crime, there has to be a law that says that the activity is a crime. Okay? Moving on. As pointed out earlier, the criminal law deals with harm to society as a whole. And so this next section of this presentation, we're going to go in a little bit more in depth with criminal law to give you a perspective of it, a general perspective of it. All right, the source of criminal law. I already mentioned to you that it's mostly found in statutes. It's also important to note that criminal law is mostly mostly found in state statutes. Obviously, if you're paying any attention to anything in America, you know that there are federal crimes. And of course, since the source of criminal law is from statutes, that means the legislative branch of both the federal and the state governments are making laws that tell us that certain behaviors are criminal behaviors. Congress makes federal criminal laws. The point is that states mostly make criminal laws because states, under the 10th Amendment, have the federalism concept that we've already discussed in this class. States are making laws that affect the health, safety, and morals of its citizenry, and that's state law. But when there are problems nationwide that have a much larger scope, drugs, for example, gun control, these are areas that the Congress of the United States has chosen to become involved with in terms of making statutes, legislation that reach into the area of criminal law. So statutes are the answer when you're wanting to research whether or not something that's happened is a criminal matter, and what governs it is going to be found in statutes. As I point out, very rarely does criminal law deal, or very rarely is common law a source of criminal law. In addition, the crimes are classified, and they are based on the type of the harm done and the nature of the punishment imposed. And felonies are more serious crimes than misdemeanors. Felonies carry a prison sentence, as opposed to misdemeanors that carry a fine or a jail sentence. When you hear about the big house, the terminology means prison, and would be of the term of 1 year or more if for committing and being convicted of a felony. Whereas misdemeanors, those are minor crimes and usually punishable only by a fine or jail sentence of less than 1 year. Categories of crimes are also important to understand on a very general level. We have crimes against persons. Homicide, kidnapping, sex offenses, assault, and battery are all examples of crimes against persons. When they affect the personhood, the personage, I guess, is a word, they are considered a crime against persons. Crimes against property, theft, robbery, burglary, arson, and trespass, for example, are property crimes, and so this category falls into property crimes. A third category of crimes is crimes against public health or decency. Drug offenses, bribery, gambling are all crimes that are have to do with public health or decency and fit into that category of crime. Crimes against the government itself, such as treason and official misconduct, that means misconduct of officials, that is a category of crimes against the government. And all of these fit into the one way of looking at the categories of crimes is that it fits into the classification of crimes. When determining the nature of punishment, crimes against persons have a greater penalty than crimes against the government. The death penalty is probably the best example. In some states, the death penalty is permitted, but only in first-degree murder cases. As far as I know, I don't know of any crimes against the government that carry that high of a penalty. Nor do I know of any property crimes or public health or decency crimes that fit into that penalty either. Anyway, just a good way to see that is, there is the context of the category of the classification of crimes and the categories of crimes that sort of fit in together, so they're not just mutually exclusive concepts. Next is an important Latin term called prima facie. Prima facie means that what the prosecution or the plaintiff needs to do is prove that the elements of the prosecution's case or the plaintiff's cause of action do exist, in fact, happened before they can bring a claim. And when they do bring the claim, the prosecution or the plaintiff, when they do bring the claim, it's necessary to prove them at trial too. So the initial, after looking for the source of law, or let me reword that, once we do the research into the source and find in the source of law the elements of the crime or the wrongful act done in a private claim, like civil claim, we always look to what are the elements. Criminal cases have two elements that are always in existence, and this goes way back in time. And Chapter 10 again will give you some more insight if you are interested in criminal law. But this slide deals strictly with the area of criminal law and the prima facie case that the prosecution must prove at trial in order to be successful. The first is called mens rea, and the second is called actus reus. These are larger concepts of what we're going to look at in a minute with an example of a crime statute, a statute that describes a crime. But every crime in criminal law needs to have the requisite bad intent or state of mind, meaning the state of mind of the person who committed the crime must have the intent of having to have committed that crime. Actus reus, another Latin term, so there are 3 Latin terms on this slide, is there has to be a bad act. So actus reus is needed one of the 2 elements that are absolutely required in criminal cases to make a prima facie case, meaning that if these 2 elements are proven, the case can go to the jury. If the prosecution brings a claim, goes to trial, and doesn't prove bad intent or doesn't prove that there was a bad act at all, then we don't have a prima facie case. These are initial questions that the prosecutor is looking at before they even bring a claim. So let's look at prima facie case in an example. On page 73, there is a section about a third of the way down called Discussion Question. And it reads, take a moment to read the following Massachusetts statute regarding larceny on page 73. And it has this statute: whoever steals, and with intent to steal, the property of another shall be guilty of larceny. Alright, so there are 4 elements, basically. 4 elements to this crime of larceny. To prove guilt, you need to show that a person steals something with the intent to steal, and that what they steal is the property of another person. The first example, example A on page 73, Alan got into a car knowing that it was not his, hot-wired it, and then drove off in it. Is he guilty of violating the statute, and why? Well, think about that for a minute. He had knowledge that the car wasn't his car, and so he knows it's another person's car, and he has the intention to steal the car, and so he has in fact stolen. Logic would prevail in knowing that he has committed larceny because these elements have been met. In addition, on page 73 still, there's a second example, and it says, assume Bill, another person, approached a car that he intended to steal but was scared away by a passerby. Is he guilty of violating the statute? Well, Bill approached the car that he intended to steal, so he has the requisite intent to steal the car. He got scared away, so he never stole the car, so he hasn't met the larceny statute. He's not guilty of larceny. He may be guilty of attempted larceny if there's a statute for that. We would need to look at the elements of that crime. But in order to meet a prima facie case in Massachusetts for larceny, that is, one needs to prove these elements that are set out. Whoever steals, and with intent to steal, the property of another shall be guilty of larceny. Let's look at example C on page 73. Assume Charles, another person. I love the way they picked only men. Sorry guys. Charles got into a car. He thought the car was his friend's car. He hot-wired the car, but he only meant to borrow it. Is he guilty of violating the statute? Well, he didn't intend to steal the car. And so, you know, this is not a prima facie case that's been met. So another problem with intent is proving intent, and that goes into a different conversation. But technically, because that requisite intent, which is required for criminal matters, is not there, it's like the unintentional picking up of someone else's book bag in the outside of the bookstore. You leave your book bag there and you walk out and finish your purchase, and you come outside and there's a pile of book bags, and you take someone else's book bag. It looks just like your bag. You walk away, find out later it's not your book bag. You don't have the requisite intent to meet a prima facie case. So there are other things, other crimes that might need to be looked into in the statutes to see what that person might be guilty of. Okay. Now, the main goal in any case, the main goal, I should say, of the defendant in any case is to try to either negate the case by saying you haven't, plaintiff or prosecutor, you haven't met the required elements. So we're going to negate the case. Think of a table with 4 legs. If we knock off one of those legs off underneath the table won't stand. So if there are 4 legs on the table and one is knocked off, it hasn't, the case is negated, and there is no criminal claim because the plaintiff hasn't met the prima facie case. Or, and I made this "or" in all capital letters to also see that there may be evidence that the defendant has that establishes a legally recognized justification, which is a defense. So first we try to negate the case by not meeting by showing that the prosecutor hasn't met the burden of showing that there's a prima facie case and all the elements are met, or that that there is a legally recognized justification. And two are listed here. One is self-defense. So if we feel that, for example, in a murder situation, if a person is accused of murder and that person can establish the legally justified defense called self-defense, that the act is justified, where the person says, yes, I did shoot and kill the person that I shot and killed, but I had no choice because the person was chasing after me with a rifle or had threatened me in some way that led me to believe in the moment that I had no choice but to commit the crime and to kill that person to protect myself, defend myself. Big area of criminal law, self-defense, that will, again, that's a different class. Criminal law is criminal law and procedure, and so I hope you take that class. It's a very, very valuable area to learn about. I know some of the students are in the criminal justice program, and they already have a really good understanding of some of these areas. Another defense is insanity, infancy, and intoxication, and the idea here is the claim of the prosecution is negated because we don't have the requisite intent if we are insane or a minor person or intoxicated, and there are not just that a person got drunk or high on drugs. It's usually a situation where it's looked at more than just I was drinking too much. This insanity defense is something in the news today as I finish up this, as I work on this. Just today, yesterday that is, last evening, Julie Shineker in Tampa, the mother who shot and killed both of her teenage children, was found guilty of murder in the first degree. But her whole trial was, after the prosecutor put on the case, was to prove that she was insane and unable to possess, as a result, the required intent. And you notice the evidence, if you were watching the media at all on this, that intoxication was involved, but insanity was the defense that she chose, because intoxication is just a whole different. She was voluntarily intoxicated, if that's what was wrong. Involuntary intoxication is a defense. Voluntary intoxication is not. Insanity, then, is a very rarely used defense. And if you were also watching the media, that's a good example. Julie Shineker case is a good example of, she knew what she was doing, and insanity would say, I was incapable of committing the crime because I was insane at the time of the crime. And in Chapter 10, there's an example of the two different types of, the two different legal perspectives of the insanity defense, which I won't go into now. But again, take a look in Chapter 10 if you're curious and want to learn more. Moving on then to civil law, and again, civil law refers to private actions brought by individuals to address perceived wrongs, but we're going to look again at, in contrast to criminal law, the concept of a prima facie case. The same thing, the same burden comes around. We have to prove there are elements listed in the crime, in the statute or common law, and we write those down in a complaint, and we have to prove that we have a valid cause of action because the plaintiff has evidence that proves that the elements of the claim, or the cause of action that is, were met. So it's the same concept, and now we're just going to look at it in a civil perspective. So we have an example. The standard example. We use it a lot in law classes. The civil case example, the car and the truck collided at an intersection, and the driver of the car is injured and wants to sue the truck driver, alleging the truck driver ran a red light. So here's our example. The first thing that happens is a complaint is filed by the plaintiff in the court with jurisdiction over the case. Jurisdiction means power. It's their courts according to statute and the constitutions in some states. It depends, but there are different guidelines that only the court that has the power to resolve the claim can resolve it. That's a different story for areas like Chapter 5 and 6 to come. But a complaint is filed with by the plaintiff, and in that plaintiff, the car driver is the plaintiff. The defendant is the truck driver, the one that ran the red light. The type of claim is negligence. We do the research, we find out that negligence is a tort. It's a civil wrong, something that would definitely be a civil claim. And in the complaint, we explain what happened. On or about thus and so day, the defendant was driving a truck, and ran a red light at the corner of thus and so, and hit plaintiff, who was crossing the intersection and had the right of way to cross that intersection. And the truck driver was careless, didn't yield to the plaintiff by stopping when the light turned red, and as a result, the duty that the truck driver has to yield right of way is breached, and as a result of that breach, the plaintiff, car driver, sustained injuries, and such as broken arm, bashed up car, loss of time at work, etc. So those are the elements that we have to prove if we're representing the plaintiff in this negligence case against the truck driver who drove carelessly. And again comes the area of the prima facie case being met. In a tort claim of negligence, the elements include 1, the duty, that the defendant owed the plaintiff a duty, and that's easy. We all owe each other a duty when we're driving on the roads, to use care and to follow the rules of the road. That not following the rules of the road, element 2, is a breach of the duty to follow the rules of the road. Pretty simple concept. And causation, that not following the rules of the road caused an accident, and harm was caused because the accident was had, and the plaintiff sustained injuries, loss of work, wants to be compensated now to put the plaintiff back in the position he or she was in prior to the accident. Next, we look at the example of burden of proof. In a civil claim, we have the preponderance of the evidence burden of proof. And then, after the plaintiff puts on their case and presumably meets the prima facie case and has the preponderance of the evidence to meet that prima facie case, the defendant comes in and says, okay, I wish to negate the plaintiff's claim, or negate the plaintiff's case. 1, didn't meet the elements. Plaintiff didn't bring up enough evidence to prove that this happened, or that there's a witness that says the truck driver was not supposed to yield because the truck driver had a green light, not a red light, and so all the elements aren't met. So they're negating the case. Or the defendant might have some affirmative defenses. That's where the defendant, basically, affirmative defense is when the new evidence is brought by the defendant that helps to avoid the judgment that the plaintiff. So a prima facie case has been met, but like in a criminal claim, there is a defense to it, a legal defense to the claim. Two of these are the negligence. There are two types of negligence used in America: contributory and comparative negligence. So if the defendant has evidence that shows that the plaintiff had contributed to the accident, maybe the plaintiff was texting and driving, not being as attentive, and so the plaintiff shares some of the liability or fault in this accident having happened. And if the elements of negligence aren't met, then the claim is negated and not a prima facie case. So this is a looking at the defenses or the negation of a crime, of a civil claim, based on that duty, breach, causation, harm. In our present example of the car and the truck at the intersection, that would be a negligence claim, and those are the four elements of such a claim: duty, breach, causation, harm. And if one of those elements, like the leg of a table, is knocked off, then out from under the table, then the table would fall. So that would be negating the claim. Then we look next to the civil damages. We talked about the comparison of the criminal versus civil in sanctions and remedies. That's what it was called on that chart that I showed earlier in this lecture. And the civil damages, again, differ from criminal. In civil cases, there are compensatory damages, there are punitive damages, and there are nominal damages. Compensatory damages are meant to put the plaintiff in the same position that he or she was in prior to the event. This could be monetary damages for lost wages, medical bills, as examples. Punitive damages in civil claims are not had very often, except where there is a heinous type of fault. Fraud, for example, could be considered one of these types of claims where punitive damages might come into play. Nominal damages, it's where it's hard for the jury to put an exact number on what the plaintiff needs to be compensated. So it's difficult to quantify it, and if it's difficult to quantify, then there may only be nominal damages awarded to the plaintiff. It can't be quantified at all. So those are the types of civil damages versus the criminal, where there's life, liberty, and death. I mean, there's those three things: life in prison or imprisonment. There's a lot greater harm involved, or a lot greater penalty involved. So areas of civil law. When do you end up in a civil claim? Well, somebody makes a deal with you and they renege on the deal. They don't fulfill the terms of a contract. That's an area of civil law. Or someone crosses over your property, and that's an area of civil law. They're constantly, regularly trespassing across your property without any need to do so, and that's a property law. Or someone else owns the property, but you seem to think it belongs to you for some reason, and so you would have a civil claim. Torts, we talked about one. Intentional negligence and negligence per se. Negligence is a private harm, just like the car accident. The car accident that we talked about earlier would be a negligence claim, but intentional tort would be, let's say the person is, screaming down the road, and the red light, it goes, say the car is stopped, and then suddenly sees his worst enemy, and runs the red light after seeing his worst enemy there. That's an intentional tort. Battery, or where someone chases after another person and hits them in the face. That's intentional. Well, it didn't happen just walking down the road and somebody slips and falls. That's negligence. In a negligence claim, there are, for example, and it isn't just in negligence claims, but that's how I've titled this slide. But in civil claims, such as negligence, we look to situations like the contributory negligence that I brought up earlier. If the plaintiff is also negligent, and this can result in a contributory negligence state, Florida is not a contributory negligence state. Other states, and I can't tell you offhand which ones they are. The book might have something in there. But some states are contributory negligence states where if the plaintiff is even, 1 scintilla responsible for the negligence, then the plaintiff takes nothing and wins nothing, even if the defendant is liable to the plaintiff. That has such draconian effects that most states have long ago switched to this third point, comparative negligence, where if the plaintiff is a percent responsible, they measure the percent of responsibility of the plaintiff, and then they take less than the full recovery, and recognize that if the plaintiff is as much as 50% responsible, then the plaintiff takes nothing because it wipes out the claim. So if the plaintiff is 10% responsible, they lose 10% of their damages, more or less. Assumption of the risk, the second point on this slide, is that the plaintiff assumed the risk. You think about the ball game. If you're going to go to a baseball game, the back of the ticket always says, oh, by the way, their balls are flying around all over the place here. You might get hit, and guess what? You're at a ball game. That's just the way it is. So that's something that is important to understand as well about negligence. So and this is a way of negating the negligence on the part of the defendant. Strict liability, that's where the plaintiff is sued and they're guilty due to the fact that the plaintiff is involved in inherently dangerous activity. Think of strict liability as it doesn't matter how excellent your safety practices are. When you are a business that uses dynamite to take down buildings, then you can be strictly liable to the public because that's an inherently dangerous activity. Despite the fact that you have trained people working for you, despite the fact that all these safety measures that take place before and during an event of an explosion, a planned explosion, it doesn't matter. It's inherently dangerous, and the plaintiff is guilty no matter what. These situations are also come into the food service industry, by the way. Food service has inherently dangerous activity, that of serving food. Years ago, Jack in the Box, I don't even know if Jack in the Box is still around. It was when I was a teenager, and it was like a hamburger place, and Jack in the Box was sued for salmonella poisoning of its patrons, and as a result of that, they took a lot of interesting liability again for serving food that was not properly. Didn't matter if they disinfected the whole place or not. The food itself was tainted with the salmonella poisoning, and there was strict liability involved. Alright, substantive versus procedural law. This is the last point in Chapter 4 on the classification of law. Why is it important? Well, we really need to make sure when we are working on a case that we realize that there are substantive law areas and there are procedural law areas. And substantive law is the law that creates rights and duties to each other. And it's the part of the law that defines what kinds of actions we take that could violate the criminal law, and also in a civil context what our rights and duties are to each other. It establishes these elements we were talking about. If your duty is to, is not to steal, then the substantive law on theft would explain what your rights are. Your property is protected, and if your property is stolen, then the following elements need to be met. That's substantive law. Procedural law is a system. It's a technicality. When you hear these things like, well, that person got off on a technicality, it's probably due to procedural law, because it regulates how the legal system works, and not necessarily how to proceed through a lawsuit is part of how the legal system works, but the other part of the legal system is the government activity. In a criminal case, there may be search and seizure problems that the government didn't follow correctly, and that's procedural law. So these two things, substantive and procedural law, are really pretty easy questions, but how it works, if it's dealing with how something works, you're probably dealing with procedural law. Think of a train, and it takes the wheels and the other whatever to move, and the tracks to move that train from point A to point B. Then it's procedural, because those things that turn the wheels and make the wheels turn, and the wheels themselves, are how the train moves. Alright, so that is substantive versus procedural law, that little bit of dialogue, or a little bit of text about it. It does, in the textbook on page 79, throw in the one of the procedural law areas of, for example, a statute of limitations. And a statute of limitations sets out the length of time from which a plaintiff or a prosecutor must bring a claim against another person. And the point is that statute of limitations is probably going to be found, is in the statutes. If you drag your feet, or the prosecution drags its feet, and no claim is brought, then the statute of limitations, as a procedural regulation of conduct that we have to, we're going to proceed through a lawsuit or bring a claim against someone, we would need to do it within the time specified by the statute of limitations. So civil and criminal are very technical rules of procedure and how to conduct search and seizure. So a quick last view of the classification of the law, just to sort of sum up what we've done so far. State and federal law control our activities, and we, from Chapter 3, learned about some of the sources of law, but this is looking at how it's classified between state and federal law. And that there are civil claims and there are criminal claims, each of which have substantive and procedural law aspects to them. So this is a very large topic. This is a very large topic. And then, of course, as I point out, the threshold question is, where am I going to find these elements? Where am I going to find out that it's civil and not criminal, or criminal and not civil? Sometimes we know this from experience. It just makes sense because of experience. But the threshold question is it federal or is it state? And knowing that there are certain sources of law for each, and where to look to start making these categorizations, these classifications, which are important to the initial research of the problem. All right, so that concludes Chapter 4. Thank you.